Our top focus right now is a verdict of the Supreme Court, where the court has delivered a landmark ruling affirming the rights of state governments to levy royalties on mineral-bearing land. This verdict by a 9-judge constitution bench led by Chief Justice Dy Chandrachud concluded that royalties are not taxes but contractual payments made by lessees to lessors. Chief Justice Chandrachud stated that the MMDR Act does not restrict states from exercising their powers to tax mineral rights and clarify that both royalty and debt rent do not meet the criteria of a tax. This ruling has far-reaching implications for mineral-rich states like Odisha, Jharkhand, West Bengal, Chhattisgarh, Madhya Pradesh and Rajasthan, enabling them to impose additional levies on mining companies operating within their jurisdiction. This decision by the Supreme Court effectively overturns a previous 1989 ruling, which had classified royalties as a form of tax, thus limiting the state's ability to impose additional charges on mineral extraction. The 1989 judgment arose from a dispute involving the Tamil Nadu government and India Cements, where the court ruled that the central government held primary authority over mineral regulation under the Mines and Minerals Act of 1957. However, with this landmark judgment, all of that has now changed. What are the implications largely for the states involved and also for the companies involved? We take this conversation forward. I have with me Ajay Dua, former Secretary, Ministry of Industry and Commerce. We also have with us Professor Madhav Nalapa, the Editorial Director of the Sunday Guardian, and Kailash Vasdev, Senior Advocate of the Supreme Court, with us on the broadcast. I want to begin with Mr. Kailash Vasdev. Mr. Vasdev, if you could firstly begin by explaining the earlier verdict and what really has changed in today's verdict to our viewers, sir.
The law as it prevailed was that royalty is a cess, and therefore regulatory effects and the regulatory regimes were different. Today, it has reversed the judgments which were prevailing India Cement, observations in Kesoram and the like. It now says that royalty is now an authority given to the state governments to impose on the minerals and lands which are holding, on which you find minerals. So therefore, the power to the states as given now is much wider than it was before, and the regulatory control of the central government is considerably reduced. The purpose, it seems, is to give the states a free hand for the purposes of collecting revenues arising out of minerals and land-bearing minerals. A wider question now arises, as raised by Justice Nagaratnam in her dissenting judgment. You see, minerals are not common to all states. Many states don't have minerals, some have, some don't have. Jharkhand has, Madhya Pradesh has, Goa has iron ore. You will find it in Odisha, you will find it in Chhattisgarh and the like, but Punjab, Haryana, Kashmir, Uttar Pradesh, Tamil Nadu, they don't have the same minerals as available in the Chota Nagpur belt. But the purpose in the constitutional scheme, as one understands it, is that you must have a taxable element which is available to the central government for even distribution of resources collected through the Consolidated Fund of India. In the administrative, in chapter, in the Constitution, there is a scheme in which finances are dealt with, both for the state and also for the union. If you have a system where taxes are to be regulated, controlled, managed, they're under a certain principle which is presented to all of us in the national budget, because that's how you allocate funds for all sorts of purposes and how you generate funds. With this individual power going to the states, there is going to be an imbalance, because some states will get collections which will be much more than what the other states have. The allocation of funds system will change considerably. Now, these are aspects which will have to be ironed out after the judgment is made available to all of us to understand in detail. But the crux of it is that the old regime has now changed. We have a new regime in picture. We will now have to balance the constitutional functions with regard to the center and the state in the allocation and collection of funds all over for every purpose, with the minerals playing a very important role for those states which hold minerals and playing a negative role for those states which don't hold minerals.
Right, absolutely.
So this is to be seen as we go along.
Okay, all right. I'll come back to you in just a moment, sir. Professor Madhav Lalupal, bringing you into the conversation, sir. What are your thoughts on the larger implications of this historic judgment by the Supreme Court today?
Well, I'd like to point out that the Supreme Court has basically expanded the rights of the states vis-a-vis the central government. And essentially, as has correctly been pointed out, those states with large mineral deposits will get a higher amount as tax. There's no question about that. At the same time, we have to remember that many of some of the states that have come forward to argue that they have the right to levy this, they include Jharkhand, they include Odisha, they include Assam, I'm told even Uttar Pradesh. Now, these are BJP-ruled states. So BJP-ruled states as well as non-BJP states are in a way united in ensuring that the state has more power to levy taxes. And another factor that needs to be borne in mind is, in my view, competition among states is a good idea. Let the states compete among each other for development. And in that competition, what happens is that there are some states that will attract investment irrespective of mineral, other states that will rely on minerals. But that cannot be a long-term solution because minerals will run out. If you push the royalty or rather the tax too high, then that will increase the production cost of these minerals and open the door to imports. So I think that limitation is there, which I think the states need to keep in mind. But having said that, there is no question that after the 1989 judgment, most of the states that have extensive minerals deposits are still lagging behind states that are basically leapfrogged that stage and gone into manufacturing and services in a big way. But of course, Tamil Nadu is an exception. Tamil Nadu has done very well economically and is also arguing the case of its minerals. Now take, for example, Kerala, thorium. I think thorium is now going to become a very important element in nuclear power production. We need a smaller, economically viable thorium-based plants for nuclear power. Kerala is very rich in the monazite sands that are very rich in thorium. And so far, a lot of these sands have been exported, mostly to China, or just leased into the sea. So I think this will make sure that state governments protect their mineral resources much more than some of them have. And I think it will promote a kind of a competition among them to ensure that they have a tax regime that keeps production high and the cost lower than the international price, so that Indian minerals can compete in the global market rather than the reverse happening, which is minerals from abroad come and flood the Indian market while Indian minerals lie unutilized. So I think that's my take, and the fact that these BJP-ruled states have also joined it indicates the central government is also aware of the situation, because it's difficult to believe that the central government were really, very determined to ensure that this regime, the 1989 regime, can continue. Well, I think they could have tried to persuade its own state governments, please don't challenge this very much. It has not obviously done, that kind of a persuasion. And as a consequence, I think the states have expanded their rights of taxation and expanded their base of revenue. And if they use it wisely, there's no reason why the entire nation cannot benefit from it, including through exports.
Absolutely. Okay, all right. I'll come back to you in just a moment, sir. Ajit, who are bringing you into the conversation, would you agree with the assessment of Professor Nalapa that this move could perhaps also increase competitiveness amongst the states as far as the taxation going ahead is concerned, that it depends now entirely on what really are the level or what really is the percentage of taxation that is going to be offered by a particular state to a mining company for them to set up base in that particular state?
Yes, while in principle, I would agree with what Professor Dalapat has said, but with one proviso, that is, we are talking about minerals. Minerals means quantities, volumes are huge. And the nature of the characteristics of minerals depend largely upon geological facts, and they vary from state to state. So the competition which is possible between, say, iron ore of Goa and the iron ore of Jharkhand is, yes, to an extent possible, but if the iron ore of Goa has Fe content between 50 to 55%, and of Jharkhand goes up to 65 to 70%, there is hardly any competition. Though we are talking about iron ore at both the places. These characteristics would limit the competition between the states. That's number one point which I wanted to make. Second was that let's recognize the fact that comparative advantage of every state in the country, in the union, all the 29 states plus the 7 union territories, varies from place to place. So let the states, with their respective comparative advantage, 7 of these states have most of the minerals, with Orissa 40-odd%. Chhattisgarh, Jharkhand, the so-called Chota Nagpur belt has most of it. But other places may have other advantages. Punjab has advantage of soil because it's a rich soil with rivers flowing through it. So their source of revenue need not necessarily be mining. It would be higher land revenue on land, or higher taxes on food processing, food procurement, any kind of activity related to agriculture. The advantage of Maharashtra, the western Maharashtra, if we forget the Vidarbha portion, Vidarbha is a part of the Chota Nagpur area, which has the minerals. The advantage is in trading and industrial, manufacturing and related purposes. So their source of income comes from those kind of processes. So I am very happy actually that this judgment has come from the Constitution bench of the Supreme Court, which recognizes the unique characters of each state and gives them the due, which is what is due to them, saying partake as a state, partake a part of that prosperity which has been endowed in you, and that it is not a tax, which I think it was very clear. One couldn't talk much about it earlier, though we've dealt with this issue in the past, particularly when talking about coal, thermal coal, met coke, etc., saying should the center be getting the royalties or should they be going to the state governments? But the fact is, I'm reiterating that it was a highly desirable step which has come about, and that there should be no attempt, and actually there is hardly any forum if a constitutional bench has given a judgment where the central government or any other aggrieved state can go saying, what about us if the royalty is going to the state governments, other state governments, not us, so be it. Finally, I would say on this subject that each state let it develop upon its own strength, rather than saying that why is that state able to collect more from royalty? Then you could say, why is Maharashtra able to collect more from GST? Because there is greater production, or Gujarat able to collect more from there. Finally, sorry, I'm using the word more than once, that if it results in skewed distribution of resources, you have the Finance Commission, which reviews the state's finances every 5 years. It can always look at saying that if this state is able to earn more by way of its mineral strength and the impositions of royalty etc. on it, then that state deserves less financial support by way of transfers from the center, which the Finance Commission reviews from time to time.
Right, absolutely. I'll come back to you in just a moment, sir. Mr. Kailash Srivastava, if you can also just further shed light on what was some of the bases on which the Supreme Court came to its decision.
See, the basis on which the states came to the Supreme Court was that they said they have a right on the constitutional interpretation of entries 49 and 50 of the lists. That is to say, minerals and land-bearing minerals, or land which bears minerals. So their view is that we have the facilities, we have the amenities, you cannot call royalty a tax. Because if you call royalty a tax, it's a misnomer. Tax is a different area, royalty is a totally different area. Royalty means the right to charge for the purposes of use of the land and the generation of minerals. Tax means it's a levy on that, which then comes into a totally different domain or a paradigm, which is totally different from royalty. That has now been put at rest by the Constitution bench by saying royalty is royalty, tax is tax. These are two different elements. Therefore, as the states are concerned, they are bound to have and they are entitled to collect their royalty, is what has been now held. Something which has been the view of the states for a long time, because they have also demanded, many states demand royalty, as Mr. Dua just mentioned, on what they are doing. They wanted a certain hand of independence away from control from the center in the federal structure which prevails. In the federal structure, what has been happening is that the center has become has been controlling and regulating everything, more at the peril of the states. The states have to take permission, they've got to get. There's a whole constitutional scheme under which states levy taxes and royalties. So now that has been considerably watered down because power has been given to the states for the purposes of collecting royalty on what they possess as their basic inherent their inherent goods, their own supply, which has been given to them by nature. Those states have minerals, they don't have other items. So you've now got to look at a balance in the overall federal structure, that there is no loss to anybody and there is no unfair gain to anyone. Because minerals are not created by man, they are given by nature. Insofar as the development of other facilities are concerned, whether it is trade, whether it is development of industry, that is done on a planned basis by the governments for the purposes of a particular state. A state may decide to develop a particular form of mineral, a particular industry, the other state may do something else. One may go into retailing. See, there are areas which are only retailing. There are states which are basically surviving on excellent retail systems on the basis of trading.
Yes.
They have the advantage of the sea, so they are trading over there. They are permitting goods to be transported. They are using those facilities. Now, ports are coming up all over. So, you see, in our country, we have a fascinating situation where we have to balance the entire economics. Here, the Supreme Court has said, so far, states have been asking for it. Now they have got it. The other states will now say they have the benefit, so please give us some benefit. So what I said earlier was we will have to balance the whole situation between the states which have minerals, don't have minerals. Some states have industry, other states don't. For example, the Northeast. How do you balance that? Excepting for tea, and Assam and Meghalaya having limestone, how do you balance the rest of the states? Tripura, Arunachal, Nagaland, Mizoram, Arunachal, their only resource is basically timber. So, and agricultural produce, the fruits and all which come from those states. So we will have to have a complete relook on the planning of the nation in the matter of finances after this judgment. It needs a balancing between all the states which have different facilities, different amenities, different resources, different positions. Because royalty alone is not going to run a state.
Yes.
Taxes alone is not going to run a state. Distribution of the national wealth will now come into the picture on a restructured format, because if it is not going to be in the control of the federal government, that the central government, it will go to the states. If some states benefit, you will have to now control what is released from the consolidated fund to these states. What is the taxation regime? How do you distribute the GST? How do you distribute the other taxes? How do you work out the customs duties? So a lot of things will now open up. It's a very unique situation where, as a democracy, we are developing into a more democratic pattern.
Okay, all right.
Something which we have overlooked for a long time.
Right, absolutely. I want to bring back Professor Madhav Nalapat into the conversation as well. Professor Nalapat, what doors does this judgment then open for certain states like Jharkhand and Chhattisgarh, which continue to be extremely mineral rich. Chhattisgarh is the second most mineral rich state of India. What doors does this open then for these states which have perhaps not been able to tap into the resources that they have?
Well, I'd like to point out that 10 years of Modi, especially Modi 2.0, has really concentrated on creating the framework and the systems by which each state can develop, and thereby, in a sense, increasing the power of each state and the potential of each state. Now, take, for example, land. Land is such an important resource. There are some states where land acquisition is very difficult because the rates they give for land acquisition are completely, they're so low, there's no comparison to the market price. You have to give rates that are reasonably in sync with the market price, and if necessary, give it in the form of money, or you take double the land that you need and distribute half the land that you have taken to those people whom you have paid compensation for the other half. That way, they'll have valuable land, which once the development takes place, will become very high in value. So I'd like to say agriculture, for example. In some states, because of MSP, they concentrate on certain crops when they can go in for so many different crops, including crops that can be exported. Fruits, for example. India can have a tremendous export market in fruits and vegetables. Now, if only, for example, some of the states that are producing a lot of rice or wheat, if they produce fruits and vegetables, we can have a huge export market. And so, frankly, that kind of competition is healthy, it's good, which is why, in my view, the central government has not really, acted, behind the scenes energetically in preventing its own state governments from supporting this point of view. The point is that every state needs to compete. And in that competition, let us see which state run by which party does better than other states run by other parties. Then let the citizen decide which party to vote for. Thank you.
Right, absolutely. Ajay, your thoughts on the same as well?
I'll just add one bit to what has just been stated by the two panelists, that a reason for giving or allowing the states to collect the royalty on minerals is also the fact that it is the state governments which directly bear the burden of mining being undertaken in the state. Yes, there is value added for the miner, but there is also considerable cost of doing it for the state government. State government has to arrange, to start with, the facilities which are required for undertaking mining. It may be water supply to be brought to that area, electricity to be brought there, and all kinds of other facilities like roads for transporting the minerals. So, and a new thing which is all mandatory is that the states have to ensure that the land which has been mined is refilled for environmental purposes, that there are no kind of dumps are left or excavated land is there. So the point I'm trying to make is that the cost which the state governments are required to bear directly, as also the social cost of getting that done, would now become a little easier to meet if they also have a source of revenue from the very fact of the mining having caused it, because they will be entitled to get certain rent which the court has allowed. That is also, in addition to the royalty, the court has also allowed the states to levy the ground rent for the land being leased.
Under the lease.
Yes, and the second, the royalty rights. So I'm actually happy that whatever is being, states are expected to do, these 7 or 8 states where most of the minerals are concentrated would have an opportunity to discharge their duties, legal duties as well as the other duties to create jobs, the If there's nothing else happening in Orissa, they go for mining. Chhattisgarh, major vocation is mining because it's difficult to do anything else. So that's for their own citizens. They have to create the jobs. This process will facilitate development, and distortions any vis-a-vis other states can be corrected if required through the mechanism of the Finance Commission and special purpose grants, which all the finance commissions in the recent past have permitted it. They allow that to happen. So this will, I think, we need not worry about distortions on a large scale occurring merely because of today's judgment.
Okay, Mr. Vastev, I'd also like to understand the fact that the Supreme Court has now given in ruling that royalty does not account as tax. Does that open up the Pandora's box for certain other matters as well?
It is going to change the system, may I put it to you that way. Earlier, royalty was a tax, so it was accounted for differently under the constitutional scheme or under the accounting systems followed by the government of India and the government of the states. Today, if you say royalty goes into an individual pocket, it is going to make a peculiar dichotomy where it will have to be balanced. Because, as I said before, and I think all of us feel the same, that only 9 states will be benefiting from this judgment. What about the remaining 20? So the other 20 will now have to be balanced because minerals have a huge amount of royalty. No industry survives without royalty. There are exports, there are all sorts of things which take place. So you will now have to bring about a serious balance in the incomes which come to the states through royalty. It is no longer a tax. So you will have to reconsider, even the Finance Commission will have to reconsider what is the impact of this royalty for the purposes of budgeting and a federal structure for the entire nation. You're not going to look at it as an individual state. Now you're going to look at royalty going away, the taxes going away from the center. Because earlier the regime was the center would control the financial arrangements. Today the states will be regulating their own affairs. How do you balance it? How do you look at it? These are the issues which are going to arise. They are the wider issues. The court will look into this. I mean, if the court doesn't look into it, the government will have to look into the impacts of this. But the impacts are definitely going to be there if you take away the existing system and bring in a new system totally. The new system is going to be, how do you balance it?
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.